Yes.
May I please, Your Lordship? So item number 18.
Yes.
It may be come after 2 weeks, my lord.
No objections, Lordship.
Why?
After 2 weeks, my lord.
Why you are saying
No,
that?
there is some negotiation with the district collector DC for settlement because we are claiming some compensation for constructing road. They are demolishing our houses and other things.
On the prayer of Mr. H. Hazarika, learned counsel of the petitioner. This is met after 2 weeks.
Yes, much obliged.
May I please, Your Lordship?
Yes.
Lordship, I beg to make a mention of item 3.
Item 3. Yes.
Yes, Lordship. Lordship, I'm praying this matter may be listed after a week's time.
What is the matter about?
Lordship, this is regarding home guards. So certain, there are 3 petitioners in this matter, Lordship.
These are service matters.
Yes, Lordship, it's a service matter.
Service matter.
Yes, my lord. They were working in the AG office from the Home Guards and their services were terminated abruptly.
In 2016, matter is pending 7 years now.
AG is the main contesting party, Mr. Rakhal Devnath, but then he is not present here. State is just a formal party.
Okay. That's right. On the prayer made by the learned counsel for the petitioner. This is met after 2 weeks.
Lordship,
Items 3.
obliged, Lordship. Lordship, a similar prayer for item 7, Lordship.
Item 7 also your petitioner.
Lordship.
And who is the
7
other
and
side?
8 are similar matters, Lordship. 7 and 8 are connected matters.
And who is the other side?
I'm for JHDC or...
No objection.
Document 7 and 8 and private respondents.
You're objecting.
No objection.
Okay. On the prayer made by learned counsel of the petitioner. And not objected by the counsel appearing for the respondents. This is matter after 2 weeks.
Lordship,
7 each.
highly grateful, Lordship.
These are all with old matters.
May I please, Your Lordship? I beg to mention item number 2, 5, 10 and 11.
Then what remains? 2, 5, 10 and 11. Every
Your Lordship. The counsel for the petitioner is not keeping well, Your Lordship.
who? Mr. Jha.
Yes,
What happened?
fever.
Fever. He's at home.
Yeah.
These are all old matters. See, 2 is 2015 matter.
Yes, Your Lordship.
Lordship, for item number 2, it's still pending before the apex court.
2 is still pending before the apex court. Two, 5 and
2, 5, 10 and 11.
everywhere is petitioner.
Yes.
Lordship, 10 and 11 are connected.
Ten and 11. Why page is missing in the cause list? 6, 8, then 11, 12. Where is 10? Oh, this has been done. Santos. 10 has come below that. It's okay. This has come here instead of placing it here. It's okay. It's okay. It's okay. It's okay. Okay, item 2. Miss so submits that Mr. Arja, learned counsel, the petitioners. is not well, is not in good health, and prays that matter may be adjourned. Ms. A. Pradhan, London Council to the respondent. There is no objection. Okay. Prayer allowed. This is a matter after 2 weeks. 3-2. Then item 2 weeks. 2 weeks, huh?
Yes, sir.
And then item 5 also.
5 also.
Here also you are respondent. Same order. Then that also will come after 2 weeks. Then what more you say?
11.
10 and 11.
There also you are respondents. Both the matters. So all same order will suffice.
Okay.
10, 11 also same. Okay.
Much obliged.
Highly object. Your Lordship, may I please like item number 16?
Item number 16. Yes, here for the respondent,
Contempt.
Interment. About the petition.
Contempt.
Mr. Mohanto.
Yes, sir.
Okay, item 16.
3 weeks time.
A prayer has been made on behalf of the respondent on the ground that Mr. S.P. Mohanto, Leonard Senior Counsel, is indisposed. Is not well. Is not well. What is it? A submission. Just submission. Just say. Is not well and stop. Hence a prayer has been made. Hence prayer has been made, not a prayer. Hence prayer is made to adjourn the matter. Prayer is made to do. Mr. K.P. Bhattacharjee, after putting his K.P. Bhattacharjee, Learned Counsel appear for the petitioner has no objection. Prayer allowed, list after 2 weeks.
I think
16.
Come up after 3 weeks. Won't it?
After 3 weeks. Why? Okay, after 3 weeks.
Much obliged.
Your Lordship, I beg to mention item number 15.
You are for?
I am for the Mr. Echelon, Your Honor. Your Lordship.
No, what happened?
He's out of station, Your Honor.
Lordship, no objections. Lordship, I seek leave of this court to rejoin to one affidavit. Lordship, I have filed an affidavit, bring on record one document, placing on record the the undertaking given by the petitioner. Lordship, this matter is regarding excess payment, which was
That document is not there.
no, Lordship. I had just received recently, and I have filed the affidavit, and recently the petitioners have replied. Lordship, I seek leave of this court to rejoin to the affidavit, Lordship.
Okay, hard. Are you advocate on record here? Are you appearing here? No.
Yeah, yes, Your Lordship.
Your name is there?
Yes, Your Lordship.
Okay, hard. I'm so and so, London Counsel for the petitioner. No, you do not say hard. You just say Miss so and so, MS so and so, petitioner, London Counsel petitioner. Praise for grant of adjournment in the matter. On the ground that Mr. H. Nonglaw, the arguing counsel, is out of station. Stop. Mr. A. Karwanlang, Leonard Senior G. appearing for the state, submits that certain document requires to be placed before the court for effective hearing of the matter.
Lordship, I've already placed it on record. I've filed an affidavit bringing it on record, and the
You have
petitioner.
already placed it here.
Lordship,
Then what is the need?
the petitioner has replied, and I wish
That
to
document is
rejoin.
already part of the record.
Lordship,
Then that is not needed. Then why? It is a public document.
Lordship,
There will be always presumption of the genuineness of the same.
Lordship,
Unless a document is sought to be disputed, I don't think it is needed.
Lordship.
They cancel this thing, so and so, so and so. Just Mr. H. Karan, learned senior has no objection. After her prayer, just say, okay. Prayer allowed, list after 2 weeks.
I do oblige. Wait, please, Lordship. Lordship, I beg to mention item 12 and 13, Lordship. These are connected matters, Lordship.
Nothing will remain.
Senior counsel has some difficulty, Lordship, to
Others say,
appearing for 2 weeks' time, Lordship.
For the respondent, the 7.
a prayer has been made on the behalf of the on behalf of the petitioner to adjourn the matter on the ground of personal difficulty of the senior counsel appearing for the petitioner, Mr. R. Devnut, learned counsel for the respondent. You are also there.
State is a party.
Okay, then you just say the learned counsel for the respondents have no objection. Prayer allowed, list after 2 weeks. 12 and 13.
12 and 13, Lordship.
Yes.
Highly obliged.
Please, Your Lordship, I beg to mention item number 9. On account of bereavement in conducting counsel, Mr. J.M. Thankew's family, Your Lordship.
Last occasion also, that is the same ground, Lordship, bereavement of the conducting counsel. It was last 2 weeks.
Yes.
Till now also bereavement.
Prior to that was a medical emergency. Your
Every
Lordship.
time they are taking adjournment in this matter, Lordship.
What is the
Giving
matter
one,
about?
one excuse or the
It's a
other.
service
What is the
matter,
matter
Your
about?
Lordship. Service
Appointment
matter.
of a teacher, assistant teacher. Every time we are available, Lordship, and they'll come and take adjournment only.
Item number 9.
Item number 9.
2017 matter. Now, if that is the thing, then we have to verify the order sheet and see.
And there's nothing left in this matter. The post has been advertised now. Appointment of teacher. It has been advertised. They can participate, Lordship.
So the counsel is not in bereavement.
Yes, Your Lordship. His
For
uncle
how
had just
long?
passed away.
How long? The state counsel says that that was the reason cited for taking adjournment also on previous occasion also. We'll have it next week.
Next week, Lordship, let it be
We'll adjourn
disposed next week.
for 1 week.
Finally.
Nothing beyond that.
Yes, Your Lordship.
I may appear for private respondent.
Yes. Okay. Okay. On the prayer of the learned counsel for the petitioner, this is matter after a week. After 1 week.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 4.
Item number 4.
Your Lordship, the conducting counsel is not keeping well today. Let the matter come up after 2 weeks.
Yes, I am for the statement.
This is also 2016 matter.
Yes.
What is the matter about?
Regarding they are asking compensation.
For land.
Yes. For constructing the road from Pati to Dalu.
You are making mention on behalf of whom?
Icharnath.
It is submitted that counsel for the petitioner, Mr. Icharnath. It is disposed. And a prayer is made to adjourn the matter. Mr. Hajarika Lanet, government advocate, appearing for the respondent, has no objection. Prayer allowed, list after 2 weeks.
In this hearing, item number 1.
Here, my lord, we are challenging the order of dismissal, my lord, as well as the report of the inquiry officer.
Dismissal from service.
My lord, dismissal from service. My lord, herein, my lord, the petitioner has joined this police department, my lord, in the year 1974, my lord. Thereafter, he was posted in Tura jail, my lord, in the year 1999.
In the capacity of?
As a warder, my lord. He was appointed working as a gatekeeper, my lord. Tura district jail. On, my lord, 18/11/1999, during his while he was performing his duty, my lord, a jailbreak incident had happened, because of which, my lord, around 23 prisoners were escaped.
Sure. Quite some years back, isn't it?
My lord. Then, my lord, a magisterial inquiry was conducted, and he was placed under suspension. My lord, thereafter, my lord, he was issued a show cause notice, and he has replied to that show cause notice. But no charges, no allegation of charges, my lord, has been framed against him in the first show cause notice. Then, my lord, the second show cause notice was issued. That is at, my lord, page 26, my lord. My lord, the statement of allegation is, my lord.
Yes.
2 charges were framed. May I read, my lord, those 2 charges, my lord?
Yes.
Did not exert the utmost vigilance to prevent the escape of the prisoners on 18/11/1999 from Tura district jail as required by Rule 93(1) of the Assam Jail Manual as adopted by the Government of Meghalaya. Number 2 is you open the inner gate of the jail to call out to the one of the other warders inside the jail, thereby allowing the prisoners to snatch the keys of the outer gate from you, open the outer gate and flee. This is in contravention of the Rule 202B and 202B and 202C and Rule 203 of the Assam Jail Manual as adopted by the Government of Meghalaya. My lord, thereafter, my lord, an order was issued, that is at
Why it is second show cause? The first show cause did not.
Disclose any allegation, my lord.
There is no this thing.
No, my lord.
Statement
that is
of
not on
no
record,
statement
my
of
lord.
allegation.
My lord, no statement. That is not on record, my lord.
It is not on record.
No.
Okay.
Due to some inordinate delay, my lord,
Yes.
that his suspension was revoked, my lord. That is at page 29, my lord. That is issued on 22nd May of 2003.
Okay. Why did you reply to this show cause notice?
My lord, without any filing reply, my lord, the order was issued, my lord.
No, you did not reply to the second show cause. Your response to second show cause?
My lord, that is not on record.
Have you replied it or not?
My lord,
This is essentially a kind of first show cause notice only, not second show cause against punishment.
my lord, then my lord, the order was passed on 13th September 2007. My lord, it is at page 30, my lord.
What order?
Or, removal from service.
No, what is your thing?
My lord.
Whether you have replied to the show cause?
My lord, that is not on record. I have to get instruction from you whether we have.
Okay, this is your writ petition. How will you take instruction now? If you have not said anything, then we will assume that you have not replied.
It's not done. Take instruction.
I have to seek instruction whether I.
You will not allowed to seek any instruction on the factual aspects of it.
My lord,
there is no question.
There are several procedural lapses during these disciplinary proceedings, my lord.
No, whether you have filed a show cause or not, that should be specific. It should be specifically within your knowledge. There is no question of, you see, going somewhere to find it out whether you have.
No, my lord, that order has been quashed and set aside by this honorable court, my lord. The first order of removal, my lord.
This is the first show cause.
After first show cause notice, this order of dismissal has been issued. That order has already been set aside by this honorable court, my lord.
Okay. Yes. Proceed then. Proceed.
Well, the order is at page 30, my lord.
Yes.
So the second paragraph, the two charges are very grave in nature, and the inquiry officer has found them to be proved beyond any reasonable doubt. In view of these findings, I hereby awarded so and so the major punishment of removal from service with immediate effect under Rule 7 and 6 of the Assam Service Discipline and Appeal Rules 1964 as adopted by the Government of Meghalaya. So thereafter, since they have not provided me any report of inquiry, my lord, so I filed an appeal before the.
This is a dismissal order.
My lord.
In pursuant to inquiry held. Consequent upon to show cause, which you refer right now.
My lord, my lord.
No, but then what is the order passed by? What has been set aside, you said?
My lord, this order has been set aside.
This 2007 order?
2007 order.
Yes, then it is gone chapter. Now it is over. This chapter is over.
This chapter is over, my lord.
Yes. Now what is the...
The order is at, my lord.
What is the order impugned here in this case? In this matter?
Order impugned is, my lord, the inquiry report, my lord. And the order of second order, which is by.
So where is the earlier round of this thing order? Where is the order passed in the earlier round of litigation?
My lord, that is at.
Let us understand. You see, like, otherwise
we
we will
not.
not.
Page 44, my lord. page 44, my lord. The operative portion is at page 48, my lord. May I read, my lord?
Yes, read the operative part. You should at least get the facts first.
My lord. My lord, that para 5, my lord.
Yes.
So and so learned counsel appearing for the respondent submits that the except non-furnishing of the inquiry report, there is no other infirmity in the inquiry proceeding as alleged by the petitioner in the writ petition. He also submitted that the court, in view of the direction by the appellate authority, there is no cause of filing this writ petition. The petitioner ought to have waited for some more time to compliance of the order of the appellate authority as stated herein. However, this court is not to be charmed by the submission of the learned counsel for the respondent that even after 1.5 years of the the petitioner was required to wait for some more time for compliance of the direction of the appellate authority. Since the petitioner has been seriously prejudiced by non-furnishing of the inquiry report and non-affording of opportunity of representation against the said report, the impugned order of removal dated 13/9/2007 stands quashed. The respondent, particularly respondent number 3, is directed to supply the petitioner a copy of the inquiry report within a period of 15 days from the date of receipt of the certified copy of the order, and thereafter award reasonable opportunity to the petitioner for filing representation against the inquiry report to the disciplinary authority. The respondent number 3 is given liberty to pass final order in the said departmental proceeding. In the meanwhile, the petitioner shall not be asked to vacate his quarter as stated. Then para 6, my lord. Before parting with the records, the court with serious concern notes that when from the magisterial inquiry report, it is manifest that there was collective lapse which enabled the prisoner to flee from the prison. How the jailer who was in charge of the jail at that time was made the inquiry officer requires to be answered by the disciplinary authority before passing the final order. And what happened, my lord? The jailer who was appointed as an inquiry officer, he was the inquiry officer who was appointed, my lord, in these proceedings was the jailer at that point of time, my lord. Thereafter, my lord, an inquiry report has been provided, my lord.
Yes.
My lord, may kindly come to page 50.
Page 50, 50.
My lord.
Yes.
This is the inquiry report.
Yes.
My lord, going through this inquiry report, my lord will see no.
In this inquiry, you have taken part.
My lord. Taken part, my lord.
Only grievance was that it was not report was not given to you.
Report was not given to me, my lord. There is no list of witnesses been provided to me, my lord. I have never been heard by them.
Where have you raised all this objection?
My lord, the operative party is at page 51, my lord.
Yes.
This inquiry report is totally on the based on the, my lord, the magisterial inquiry. There is no proper disciplinary proceeding has been held, my lord, against me. There is no finding. There is no specific finding on each of the charges, my lord.
There is a type
There is
copy.
no document, my lord. There is no documentary evidence has been recorded, my lord. This inquiry by the inquiry officer, my lord. My lord, the last.
But then there is a finding recorded in this too.
My lord.
There is a finding. Inquiry says and it speaks about that.
It says on the.
It speaks about your inaction and all.
Physical verification of the spot of incident. The main gate premises is seen that there was many other alternative.
You are reading which part? You are reading.
My lord, page 54, my lord, last part.
No, but then before that,
My lord.
come to page 53.
Page, my lord.
53. And see after from the records documents after para F, the next paragraph. the charge that the charged official did not
Nothing has
is
been
true and correct.
nothing has been recorded. Who has been examined? Who has not been
Do
examined?
not expect it to be, you see, do not equate it to be any judicial order passed by a court of law.
Well, but there should be some findings on each charges, my lord.
There are 2-3 paragraphs. This speaks about it. So you contend that there is no proper inquiry.
My lord.
No finding
One more
recorded.
thing, my lord, there are around 6 of them were there at that point of time when the incident happened. All of them are still working. Only I was made a scapegoat, my lord, in this entire incident, my lord. And the magisterial inquiry also, it says that this is a collective lapse. Others are still in service.
Where is the report of magisterial inquiry?
That is we don't have, my lord. I don't have. That is in the record. It is there, my lord. I've seen.
No, but then you are trying to draw some discrepancy between these two.
My
You are saying that magisterial finding is something else.
My lord. But that is not. That has not been provided to me, my lord. So I don't have that.
Then what basis you are making that submission without going through that report?
My lord, I have gone through the records, my lord. It's
Record
there.
is here.
Record is here, my lord. Whatever documents they are saying that they have relied on, my lord, that all are from the preliminary inquiry, my lord. That is not during the period of disciplinary proceedings, my lord. I have seen the records. It says, my lord, it all are from on the date of incident, my lord. That whatever statement has been taken and all.
There is a reply by you against Fast Stockers notice.
My lord, there is a reply by me against
Where is
Fast
that?
Stockers. That is there, my lord. That is at page.
This all.
This page 22, my lord.
This inquiry report was by the jailer of the district jail, which the
Was the
earlier round of the order, the High Court said that the court, the state should clarify
My lord.
or justify.
My lord. That
No.
has not been done. My
Now
lord.
there were two more inquiry officers before
My lord,
him.
yes. Around 3 inquiry officers were appointed, my lord, during these proceedings, my lord.
And how state has justified
That
the
is a
appointment of
page-
the jailer? State has justified the appointment of the
My
jailer.
lord, there is nothing to say on that, my lord, because they have stated only one act.
Just tell what stand they have taken. Why how they have justified. Nathan, you go, you do this thing, typing. Anyway, just say, tell us what you want to say. Now your contention with regard to inquiry report is there. Then
My lord, that is, we have stated in our petition, my lord, petition that in para 6, my lord, that's she so and so was appointed as an inquiry officer in the year 2002. And again on 2003, my lord, the inquiry has been handed over to Mr. some other person, my lord. Para 6 of my writ petition, my lord.
it's okay. For it is initially
One
Mr.
she
KCM Twa.
my lord. Then my lord,
RKM
it
Sangma.
has been handed over to KM Sangma.
RKM Sangma also could not complete.
My lord.
Anyway, what else?
My lord, the order is, my lord, the impugn order is at page 66, my lord. There is a second order of dismissal, my lord.
Yes.
My lord will kindly see this order, my lord.
It says that
This is-
magistrate inquiry report was submitted to you. You denied it.
My lord. It is totally based on the report of the magisterial inquiry, my lord.
This order has been
There is-
passed by Director General of Prison.
My lord.
He is the appointing authority.
My lord.
He is the This was sent to the district magistrate. Yes, then?
Then, my lord, I filed an appeal before the appellate authority. The appeal was pending for a considerable period of time, my lord. So I have approached this honorable court for disposal of that appeal. Thereafter, my lord, the appeal was disposed of, my lord, in view of the direction of this honorable court, my lord. That is at page 90, my lord. Order passed by the appellate authority.
Page 90.
90, my lord. My lord, in this order of this appellate authority, my lord, they have admitted that there is no clear finding on these charges, my lord. The last paragraph of the order, my lord. While examining, may I read, my lord, this?
Just a minute. You are removed from service.
My lord, I am removed from service.
So, removal will not affect your appointment later somewhere. It is not a case of dismissal, which would have been a bar for your future appointment. Removal will not.
So she was correct.
My lord, he
The
has...
difference between removal and dismissal. Dismissal will create a future bar.
Yes.
Removal will not.
My lord, he is now around 65, more
It's
than
all right.
65 years.
It's all right. It's all right. We are not talking about this. So we
Right.
are not going into that. But then the thing is that it's a removal. Yes, what do you want to point out in the appellate courts or what
My lord,
appellate
it is
authorities
the
order?
last paragraph, my lord. It says, while examining the records of inquiry, I find that inquiry officer has given his findings on the statement of allegations and not specifically on the article of charges, my lord. With the result that his findings are not specific as to each article as they should be.
Now, what is the consequence of that in law?
My lord, as per the Rule 9(7), my lord, of the Assam Discipline Appeal Rules, my lord, it has to be specific, my lord, on the charges.
And what is the consequence if it is not? What is the
It has to be
what
set
is the
aside,
rule?
my lord. It has to be set aside,
Is it? Where is that?
my lord. Because the Rule 9 is mandatory, my lord, mandatory in nature. And my lord, the order also itself also, my lord, there is no specific finding of these charges, my lord, by the disciplinary authority, my lord.
Yes, but then here statement of allegation and the charges are same. No essential difference.
No, there has to be explanation to each charges, my lord. There is
No
no
finding-
explanation, my lord.
It says
no
that
finding, my lord.
finding on the statement of allegation
Only
has
on
been
the going
recorded.
to the magisterial inquiry and report.
Now, what is the difference between statement of allegation and the charge? Was there any difference in the present case?
No, my lord.
Was there any difference
My lord,
between the statement of allegation and the article of charges?
no, my lord, there is the same.
The same.
Same. My lord, the Rule 9, my lord.
This all right. Consider record of inquiry and records his finding on his charges.
My lord. My lord, I have
Does
to-
it prejudice you anyway?
My lord, it is. It will amount to violation of principle of natural justice, my lord. I'll place, my lord.
Which way it is on natural justice? You say that there is no difference between the statement of allegation and charges.
Which shows that, my
And
lord, there is no evidence
Just
has been recorded, my lord.
say
There is no
supposing-
scope of cross examination, my lord.
Had it been something like that, see,
My
the
lord.
statement of allegation is something, the charges are something different. See, like in such a case, all right, we could have understood that. Yes, that finding would definitely prejudice you. But then when it is not, then which way it prejudices you?
My lord, if there is no specific finding, it will show, my lord, it will reflect that there is no, the disciplinary authority has not gone to all these things, my lord.
No, your contention with regard to Rule 9. That is what I say.
Rule 9, my lord. Rule 9(7), my lord.
Apart from this what is the finding of the appellate authority?
My lord, appellate authority, after my lord saying this, my lord, they are saying that on the same paragraph that it has been proved reasonable, beyond reasonable doubt, my lord. Therefore, I find no reason to interfere with the order dated so and so. The appeal accordingly dismissed. Lordship, I may be allowed to place two judgments, my lord, ahead on this issue, my lord.
On what issue?
On this finding of each charges, my lord. Rule 9.
Yes, what is the decision?
Well, this is 2006 4 GLT 579.
2006 4 GLT 5.
79.
What does it say? Single bench or division bench judgment?
Well, this is division benchment.
Set aside and remanded back.
My lord.
Which part you want to read?
I read this para 8, my lord.
Yes.
That it says that the rule 9 is mandatory in nature, my lord. After carefully considering the rival submission, we are inclined to agree with the learned counsel for the appellant. It is no longer res judicata that rule 9 of the rules is mandatory, and that any action therefrom to sustain a legal scrutiny has to be in meticulous compliance thereof. This is principally as any of the order of penalty following the departmental proceeding would visit the delinquent officer with adverse civil consequences, even leading to his ouster from service, as in the present case, with a stigma. Any departure from the prescription of Rule 9, therefore, has to be at the pain of the invalidation of the subsequent decision.
Yes, we have to see what is the effect of departure. Then?
My lord, another decision, my lord, this is regarding. This one is, my lord.
So that is your contention.
My lord.
Apart from what you have pointed out with regard to your inquiry.
My lord.
That Rule 9.
Rule 9, my lord.
Is not followed.
Not
Achha,
followed.
what is your second decision? What is that?
Second decision 1996, my lord, volume 3. JLR 105.
10?
105, my lord.
What is the relevant part?
My lord, relevant part is, my lord, para 9, because here in this case, my lord, since the jailer who was the since the inquiry officer is the jailer, my lord, at that point of time, para 9, my lord, natural justice is said to demand not only that whose interest may be directly affected by an act or decision should be given prior notice and adequate opportunity to be heard, but also that the authority should be disinterested and impartial. So in my case, my lord, it is.
How do you say he was partial?
My lord, he is the jailer, my lord. So
what? Just because he's jailer, can you say he's partial?
But can he be appointed as an inquiry officer of the same for the same?
It is in view of what has been held by the earlier round of litigation that he himself was probably made answerable to the incident. Probably that is what.
My lord, it is because
that is what. But then otherwise, how can he be held to be biased against you?
My lord, from
impartiality and bias is not coming. I don't know. Where is that you have said that he was biased against you in your petition? In your
my lord, I have stated.
Where it is?
My lord, para 18, my lord. Page 14, my lord. May I read, my lord?
Just a minute. Yes.
That the petitioner submits that the disciplinary authority, though not bound by the findings of the inquiry officer, failed to exercise its judicial mind, that the inquiry report dated so and so does not contain a clear finding on each of the article of charge. Further, no statement of witness, no documentary evidence has been produced or taken into consideration while coming to the conclusion that the charges against the petitioner have been proved beyond reasonable doubt, thereby holding the petitioner guilty of negligence. The said report of the inquiry officer smacks of bias when coupled with the fact that the said inquiry officer was apparently the jailer at Tura jail at the time when the incident of jailbreak occurred.
There is nothing specific. Anyway. Smacks bias coupled with the fact. So allegation of biasness is somewhere else. You couple it with the fact that jailer. It is not that you have taken allegation against him only. When you say coupled with the fact, means some other allegation is there, somebody else.
The fact that he is the inquiry officer.
No, that is coupled with the fact.
So my main contention is that only, my lord, that the inquiry report has no evidentiary value, my lord. And based on that, my lord, the order passed by the disciplinary authority also, my lord, has not specified any finding, my lord, on these charges, my lord, before passing the order.
You see, inquiry report has no evidentiary value means?
Yes, no evidence has been discussed on the inquiry report.
Inquiry is inquiry. You can say that inquiry is not based on
any evidence. Yes, madam.
Yes. Only this much.
Madam.
Yes, Mr. Khan.
May please, Your Lordship. Lordship, most of the facts has been rightly brought by the learned counsel for the petition. Your Lordship, I'll not repeat it, but the queries,
the factual aspects.
The query that needs to be addressed, Your Lordship. Lordship, the para 14, page 14, para 18. Lordship, I'm grateful to Lordship. Lordship had first of all rightly pointed out that smacks of bias when coupled with other facts.
That is what this has gone as a submission part. It's not a
Lordship. So Lordship, this is the pleading. Lordship is aware. For the sake
this
of
is not a direct allegation.
Absolutely, Lord.
Yes.
Lordship, even if it was remotely, Lordship, let's assume it was remotely. Law is settled, Your Lordship. I'll not burden this court with judgments.
Anyway, what you will say about the
inquiry? I'll come to it, Your Lordship. Lordship, first thing was, this is very fresh, so I thought I'll just address the issue first. Even if for the sake of argument, if you just take the word bias here, and she's forwarding an oral argument, law requires, Your Lordship, the inquiry officer should have been made a separate party. He's not been made a party, Your Lordship. At least he's a fit person to.
Yes, definitely. This is a valid point.
So he's not been made a party. Who's going to address the issue of bias or prejudice?
Yes. Definitely.
State cannot answer that. So in other words, there's no case of bias or prejudice has been made out.
Yes.
And there could be, apparently, it could appear to be some semblance of some procedural lapses, minor and large. But I'll come to it, Your Lordship. Now, whether that issue was raised and whether it was answered.
The
issue of charges not being answered specifically. If it was raised, and what was the consequences Lordship had asked? She was relying on a judgment.
In view of the fact, you see, like if you peruse the record, you will not find there is any difference between the statement of allegation.
Lordship,
and
yes.
charges.
Lordship,
it's a repetition of the same thing.
I'm coming to that, Your Lordship, because that's why I'm not addressing the issue. If there was a difference, then the owners would have been asked to reply. There is no allegation. Now, the only limited issue was this: if at all they had raised the issue, and whether the appellate authority had answered that. Yes. What would have the consequences?
Yes.
Lordship, let us just come to the last page, page 90. Page 92, Your Lordship. But I'm grateful, Lordship, that issue, at least so far, the content is concerned, allegations or charges immaterial. They're not denying it.
Page 90, 90.
92. The relevant part would be 92.
Yes.
While examining the records of the inquiry, I find that the IO has given his finding on the statement of allegation and not specifically in the articles of charge. So that has basically answered your Lordship's query on the statement of allegation, but not specifically article of charge. So either way, it has addressed the issue. Am I correct, Lordship? With the result that these findings are not specific to each article as that could be. So far as statement of allegation is concerned, finding is given. On the charges, no. So the larger issue is this: whether if their submission is allegation and charges are similar, findings on allegations are not.
It's not a case of no finding.
Exactly, Lordship. That I'll come later on, Lordship. We are into a different level right now. The nuances of law. So if the argument was allegations and charges are same, so finding on allegation is clearly apparent. Now, Lordship, allow me to read. If that is the answer, that means section 9 will not be applicable and the judgment will not be relevant for the purpose. If there was no answering on the allegation, then maybe yes. On facts, it can be distinguishable. Then we have to address a larger issue whether it is mandatory or not. And Lordship, I hope I've addressed that issue. So insofar as section 9 is concerned on the issue of charge, if facts are similar, this judgment does not take care of allegation and charges. It only talks about charges. So technically on facts this is distinguishable and not applicable in the case.
Definitely, that is
absolutely.
That is in the vision.
I'm grateful, Your Lordship. So if that is answered, then allow me to proceed further. With result that
answered it. You have answered it.
Lordship, with the result that his findings are not specific to each article of charge as they could. Now, Lordship, after full stop is very relevant. my learned friend did not read out this. And I'm thankful to her because she wanted me to read out. Even so, comma, no material irregularity has been committed by IO and no injustice has been done to the appellant. In other words, it's answering the issue of prejudice. The next line, Your Lordship, there is no evidence of bias on the part of any authority concerned. Lordship, my purpose of reading this particular line, 2 line, is very crucial. If that is the line, if that is the reasoning before the appellate authority, which after High Court had directed on her appeal. So if she has raised it, and she has raised the issue of prejudice, and she has raised the issue of bias. The appellate authority says, since findings are given on the allegation, maybe not on the charges, but if at all there was a prejudice, appellate authority would have to answer that. It has rightly answered, saying that no issue of materiality, nothing.
And there is no evidence of bias.
And no evidence of bias. So issue of bias also, appellate authority is taking care of that, Your Lordship. Now if appellate authority is taking care of all these components, and if I may submit, Your Lordship, then nothing survives, because they have not gone into challenging the findings of the inquiry per se, whether evidence was appreciated or not. Lordship is read out, I will not bother this court with reading it again.
Yes.
Only thing, Your Lordship, for your Lordship's convenience, Lordship has thrown a query to the bar, whether what is the ministerial inquiry. Lordship, we have flag mark it for your convenience.
How come that finding of magistrate, how to what extent it can be relied on? Was it before an inquiry
officer? No. Appellate authority, Your Lordship, has related after the High Court's order. But the findings are independent, both are independent.
Was it proper for the appellate authority?
Technically speaking, no. Lordship, Your Lordship is correct. But that...
They have not raised any specific grievance.
No, nothing. But as per High Court order, both was given, Your Lordship. Both, Lordship has read out the first paragraph. Inquiry report and ministerial inquiry report was given after the High Court order. So they have not challenged it, neither they have said they cannot rely on it. That is not the case. Their case is specifically, my learned friend has just harped on that part, the charges, that basically her thrust was on that. And then it came down to what has fallen from Lordship, issue of prejudice, that has been answered. Bias, I have answered it, Your Lordship. And for your Lordship's convenience, we have flag marked with the ministerial inquiry report in case court wants to go through. It's an orange flag mark from the record. And if I may submit, Your Lordship, a case for interference has not been made out because, as rightly said, it's not a case of dismissal.
Future is nothing. They have not pointed out to any procedural lapses.
No, nothing as such. So that matter remains. It's a very detailed order, Your Lordship. Appellate authority has discussed at length from page 90 to 93, NHA 16. Every aspect has been covered, and it has come to a finding. There's nothing wrong with the entire procedure. So the only grievance was on the charge, which I think has been answered. And Lordship, on a factual background, it was a case of 23 inmates escaping. Other issues she raised, Your Lordship, it would not be wise for me to reply because that doesn't concern our case, whether what happened and who were let off or not. That is a separate issue, has nothing to do with.
That will not give them.
It has got no relation.
Any advantage, you see.
Exactly, Lordship. Yes.
Just because somebody is left off doesn't mean that.
It doesn't, absolutely. So I think, Your Lordship, there is no case made out for interference. And if I may submit, Your Lordship, last, I was in the last day also. I had requested her. She didn't get the hint. I thought maybe she'll amend her claim, but she chose not to. I thought it could be a case. At law, it could have been a case of proportionality on the punishment. That is not the case.
Nothing has been done. So
nothing has been done.
We will not enter into that.
Absolutely, that's what I had given a hint. Maybe the only option could have been that, but there's nothing on record. So, Lordship, arrest my case. There is no case for any interference.
We will have to peruse the record. That's the main thing.
Lordship, yes.
Lordship, I'm praying if this another day may be fixed for this matter, my lord. So I'm led by Mr. Paul, my lord. So he might have something.
After conclusion, she should have.
I thought we have concluded this.
Concluded.
My lord. Lordship allows, my lord.
You have done your part. Why?
She did it well. Actually, she the relevant part, the relevant judgment. Even I told her last occasion, she did it well.
Only next week, my lord.
See, whatever the things, the moment You see, there is a lapse of time. I forget this.
My lord, that's why, my lord, next week, any day, my lord, convenient to your lordship.
Yes, Mr. Khan.
Leave it to your lordship, but that has never been a convention. After the hearing is concluded, then he asks for time. And she did it well. That's the only thing.
That is what.
She has argued well, relied on judgment. But
No,
final
we'll
point.
close the hearing. There is no, you see,
Nothing.
you have argued the matter now. You should have stated at the beginning and all.
My lord, only a day accommodation, my lord.
You finished. You say, we'll just reserve it. If you want to give something, you can give it in writing. But then do not give a written argument. You will not. Just something. You can give gist of your argument. That is okay. That is all right. But then the written argument.
Lordship, only slight urgency in this matter was that this case has been dragging on long, and he is continuing a stay order by this court and holding on to the quarter.
But that is by virtue of the order passed by that.
And they approached in this petition, so that's why we were always in a hurry to get this disposed of. He is still holding the quarter by a stay order given in this particular case.
What was the order passed by that court?
Your Lordship.
How many rounds of litigations are there?
My lord, it's this 4th round of litigation. Order is of, my lord, 23rd February 2015.
Where is that order?
23rd February 2015.
My lord, this is
23rd February 2015, Your Lordship.
This is order. This is order. What is that?
Two 2015 order, Lordship. We are in 2023.
Yes. Just passed in a different case.
miscellaneous application.
Miscellaneous
Separate miscellaneous application.
Miscellaneous
in both,
application.
my lord.
In this.
In
In this reparation. In this reparation.
Order was passed in 2015. Long back.
And Your Lordship, he superannuated on 29/2/2012.
2000?
29/2/2012.
No, cannot be. It's the matter is. My lord, that cannot be, my lord.
Sorry. No, I'm saying date of superannuation. He was dismissed from service. Technically, if he had due of superannuation as per the service record. Had he continued, he should have continued on 29/2/2012.
2012. And his His removal was on which date?
Removal appellate authority last 2012, the last page.
2012, my lord.
Just at the vague end of the career.
So he approaches 2015 court and he continues to hold on. Of course, Lordship, I will not press to it. There can be a legal consequences of enjoying such an interim order. Since we have not pleaded, Lordship, I am not pressing for anything. Leave it to the discretion of the court.
So my matter is pending, my lord. So
Because you succeed in everything. But if you fail, there are consequences for failure.
Okay, we'll conclude it. We'll keep it reserved.
Oblige, Lordship.
my lord, I'll file a small gist, my lord, within a week, within 2-3 days.
You can give a gist of argument,
My
but then do not give a written.
My lord.
And do not expand your argument behind the back of the other side. Okay. Just reserve.
Lordship,
My lord, peruse the records, my lord.
We'll definitely peruse
My
that.
lord. But the records will speak itself, my lord.
See, I have one difficulty is one of PS is on leave.
But
Functioning
Lordship,
with one and becomes very difficult.
on a lighter note, that's an advantage of having
Now
an
already there are a number of judgment reserved. Even some are half written, I could not finish.
Lordship, but there's an advantage of having a Lordship the other side, because we have an advantage of having an experience of knowing the difficulties that we faced.
We know each other's temperament.
Absolutely. But it's pleasure, Lordship. Arguing before your Lordship is a pleasure. At least service matters, Lordship is such a big jungle.
Yes, keep it in the records. Huh?
Oblige, your Lordship.
There appears to be a written thing also.
Lordship, but we will not rely because these has all become.
My lord, these are all actually the
It's
matter
already
was-
there.
It's
already there.
She is filed.
It's not required to give anything. It's already there. The notes are already there.
Well.
You go through it.
Oblige, Lordship.
Yes, sir.
Item number 6.
An additional.
Yes, what is the matter about?
That is a matter regarding the Nokmaship dispute, my lord.
Nakmashik dispute.
Yes.
This court will understand that.
Yes.
Make sure this court doesn't commit any mistake in this kind of things. Yes, we can start. Let me try. Let
May I
us
please,
start.
Your
Let us see where we end up.
that the petitioner parents, that is Jongshan Momin and late Rane and Marak, were appointed as a Nokma of Nankra Akhin land, White Order dated 3/3/1978 by the CGM, and aggrieved by this order, my lord, the respondent parents late Alipshan Marak, late Mene Marak, filed a CRP number 936 of 1982 in the Guwahati High Court, but it has been withdrawn.
One, Mr.
Yes,
Hazarika. Now, to get your facts,
yes, my lord.
Here you can refer to this in your writ petition.
Yes.
So otherwise, it will be quite difficult for the court to record all those
that
things.
is, I am referring.
Just the facts which you are on now, where are those in your writ petition?
I am going on this.
It will be, my lord, Nokma matters. If you can give the gist first, then he go into the record. Then it will be in a better position, my lord.
You see,
for everyone to understand.
This court is first interested in getting the facts.
Yes.
So that is what
that one brief I am giving before this honorable court, my lord.
We have to get the gist first, my lord. Without getting the gist, my lord, it will be difficult.
Yes, written argument.
Does it start from para 7? Just see. Para 7 of your writ petition. Is it the start of the facts which you are narrating right now?
Para 7.
At page 9 of your writ petition.
Yes, my lord. Shall I read out, my lord?
It's okay. You see, you can submit in your own way, but then the court should get the facts. That is the main thing.
Yes. Now, that petitioners is the direct descendant of the Nankra Akhin land, my lord, which has been reflected in GT page number 19, annexure 1, my lord.
Yes.
It has been start from Jongshan Momin, that is my parents, and the Rane Marak, then come Alipshan and Mene Marak, which has been challenged and for time being, then Shimran Tengre Momin and Shora Nankra Marak, my lord, and subsequently, my lord, lastly this Medalin Marak, that is respondent number 4, as registered as a Nokma, which is under challenge in this writ petition, my lord.
His name is not appearing here.
Whose name, my lord?
See, this is a genealogical tree.
Now, my name is not reflected.
No, annexure 1.
Annexure 1, yes.
No, that is what you referred just now, isn't it?
Yes, my lord.
And you referred to which names?
Jongshan, starting from Jongshan Momin, my lord.
Yes.
And the Rane Marak name is not reflected here, my lord, my mother's.
Yes.
And after that, this Alipshan, because here, my lord, I will go in detail. Jongshan Momin, what happened? He was appointed as a Nokma. What is this written argument? In 1958, my lord. Registered at Nokma of Nankra Akhin land, White Order 8/4/1958.
Where is that order?
That is, it is reflected in the affidavit filed by the respondent, my lord.
Okay.
With one Jamse Marak, who died in 1964, my lord. Thereafter, the Klein people has given a substitute wife to the Jongshan Momin, my lord, one Srimati Rigne and Marak, but he elopes with another man, Margaret Marak. Thereafter, the claimed people again they have given a substitute wife, Rane and Marak, which is they are disputing by the respondents to Zongshan Momin. And since then, he has continued as a Nokma of Nankra Aking land. Meanwhile, a few claimed people connivance with the Alipshan Marak and his wife, Mene Marak. They have produced some document, my lord, as reflected in the affidavit in opposition by the respondent number 4, my lord. They are stating that he has not given any substitute wife, and then Zongshan Momin given a writing that he is relinquished his Nokmaship in favor of
in this writ petition. What is under challenge?
The order dated.
What is the impugn order?
15/12/2016.
Impugn order is last, my lord.
Just where is that? Just let us come to that.
Yes,
The type copy is in page 137. It started with page 137.
Otherwise, to get facts
Yes.
will be quite difficult from this court.
Yes, my lord. Page number 37, my lord. 137, Annex 4. That is the impugn order, my lord.
Yes.
Shall I read out from the beginning?
Yes, definitely. If it is, is it a big order?
It's a big
It's a
order.
very big order. 165.
The facts are discernible from here.
Yes.
Here, my lord, what happened then? Impugn order has been passed without hearing the parties.
You are the appellant here.
Yes, my lord.
Now, this appeal is against what order?
Against this order, my lord.
Which order?
That it is 15/12/2016, my lord.
Where is that order?
That is the page number 137, my lord.
No. This is an appeal, isn't it?
No, this is the judgment and order, my lord.
No.
This is an appeal order.
This is an appellate order, isn't it?
Yes.
No, it is reflected in my additional affidavit. Additional affidavit I have filed.
If it is an appeal, it must be against some order, isn't it?
Yes.
So where is that order?
That
Which has
order,
been under challenge in this appeal.
Yeah, that order is of 17/2/2020.
Where is that order? Where will you get it?
This is on page 23.
17
February 2000.
What page you said?
23.
Type copy is there. And then in the another sheet, my lord, we have given the type copy of the order 17/2/2000.
Where is it?
It is in the record, my lord. It is not clear. We have given by way of additional affidavit to type copy of this order, my lord. 17/2/2000.
Very difficult, Mr. Jarika. At least it will be more difficult for this court. Your additional affidavit dated?
Filed by me, my lord.
Yes. Yes.
Was filed on August 2015, but we are not giving the date. Yes, filed two additional affidavits. In one of the additional affidavit, only this type copy of the order is there. But the date is not reflected, but it was filed on August 2022. But in record, it might have. There's one.
No, which affidavit contains the type copy?
That is the order of this annexure, page number 23, my lord.
Page number 23 of
Annex
type copy
3.
of page number
Yes.
3 was
Where-
we have make a type copy in the additional affidavit that is
Dated?
We have not enclosed, so it is
Affidavit,
not
affidavit dated?
subsequently.
Yes.
They might have reflected in the date, but it was on filed on August 2022, my lord.
August 2020.
Also.
Yeah.
Only the type copy.
Because it is not readable, my lord.
Yes. It is there.
Shall I read out this word?
Yes, yes. Type copy got. Yes. Yes. Who is the petitioner before the original authority?
There was the petitioner before the original authority.
They are the petitioner.
Yes. And Mr. Sangma has filed an appeal before the CEM against the order which was passed in their favor. Order of 2000 is in their favor. That order was challenged before the CEM.
It was reversed. Reversed.
It was reversed. Yes.
And against that reversal, they have come here.
They have come.
Yes.
The core issue before this honorable court is this: whether, from the record, my lord has to examine whether who is from the lineage or the descendant of the last recorded document. That is the core issue, my lord.
Now, can this court determine?
Yes,
that?
from the record. Yes, under 226, because this court has the only authority to examine whether the procedure which has been laid down in Dore Sama case has been followed by the EM and CM. That is the only, because the into the
Someone says that issue has to be
frame,
and there has to be
yes. So whether this principle was followed by these two authority.
Is
If
confined
this
to
is followed, if this is followed, my lord cannot go into the facts of the case.
Definitely, that is what. See,
Yes.
we are sitting on judicial review.
Yes.
We are not sitting as court of appeal.
Yes.
So we cannot go and decide the merits and demerits of the decision.
Correct.
Rather than we are confined to the decision making process.
Yes.
And whether that there is an adherence to the laid down procedure.
Laid down procedure. Yes. Yes.
Now that is what
Yes.
the thing.
That is what my learned friend has to project before this honorable court.
Yes.
What I understand.
No, that is what you see. Like otherwise, this court also will not understand anything if we go directionless.
Yes.
That will be difficult to discern the actual facts
Correct,
and
correct,
the
my lord. Yes.
issues which are
That
required.
that is what I was suggesting. If you can give us summary, what has happened and from where he is getting that power to claim for that post, then my lord it will be more clear to understand.
No, in that case, my lord, it is reflected in my written argument. And if your lordship is
There is a written argument already filed in this matter.
Yes, this matter was supposed to be disposed of.
Disposed.
But my learned senior friend has taken time to file a written argument.
in the
The
meanwhile,
argument was completed. Probably my friend was very lucky that the matter has been transferred to this case court and he can reopen his case. Otherwise, in the earlier round, he was in a very tight situation to prove his case.
no, that is your version. That is not my version.
Definitely. We do not know who is in tight situation until
Yes,
unless
yes,
IPL verdict comes.
Everything is available in YouTube.
That is not the issue. It means there is no order which says that this is reserved for judgment or is
No, nothing, my lord. Only for waiting for the written argument. They have filed. I have not filed. I have filed. Meanwhile, this case is
Written
coming
argument
here.
was also not even given to us.
No, if my lord will permit, then I will give a gist for short.
That
See, if you make a gist, this will be very much helpful,
Yes,
for
my lord.
especially for
Otherwise-
this court.
Yes, my lord.
This court has difficulty in understanding the names and this
Yes,
the nomenclature which are used.
I will give the gist, my lord, how the thing is coming. In very short nature, gist I will give. Then your lordship will understand it very easily. But if you go for argument, it will take time also, consuming time. And moreover, gist.
Taking
then-
time is not an issue.
No,
But
then
my
okay.
friend, my senior friend, has to give the gist. Without knowing the head and tail, my lord, it will be very difficult to grip the case.
No, that is
No,
up
we
to
can
the
ascertain it, but then we have to go through this entire order.
yes.
and all.
Yes.
Why this case is there? What do you say? Your contention is that the
My simple
the laid down
contention.
procedure has not been followed or something like that. It
Yes,
is
madam.
something like that.
Yes, in the impune order, they have not given any chance for opportunity to hearing. Just simply pass the order.
The appellate order.
Yeah,
See,
yes,
you are-
in the
you are-
in the appellate court, my
You'll
lord.
be assailing the appellate order.
Yes, my lord. We are assailing the appellate court orders. And another question also that she is not the respondent number 4, is not the last recorded Nokma's daughter, my lord. Last recorded is
It is an admitted position.
yes, my lord.
No.
Yes. She is not the recorded doctor.
If it is
No.
not admitted position, how this court will determine this?
No, now they are claiming that the parents of this one, for time being, some document they have produced before this court of CM with some particular person. They are that this Jongshan Momin has given relinquished his post after the death of his wife, and the second substitute wife also deserted. So on that basis, he was appointed. As soon as appointed by this CM, sorry, my lord, executive members, EM, revenue, then and there, the Egyptian Momin and his wife Rane Marak challenged it. So it has been cancelled. And they have given me, appointed me on 3rd March 1978, Jongshan Momin, my parents, my fathers. Which one has been challenged, that is in the short, my lord, challenged by the parents of the respondent number 4, Alipson Marak and Mene Marak in the Guwahati High Court. Subsequently, it has been withdrawn, my lord, in 1993. After withdrawing, then Jongshan Momin is continuing his Nokma of the Nankra Aking land. When he was died and given this one, then this come Shura Nankra Marak and the Shimran Marak. When he was appointed on 17/2/2020, which has been challenged.
See, confusion comes where you see when these names are not remembered properly.
Yes, my lord. Then what happened, my lord? After appointing Shura Nankra and Shimran, which has been challenged by the respondent number 4. So order has been passed in their favor, which has been appealed again to the CM. So CM order, withhold the order of
these facts are there in your
yes, my lord. That is then this is the
order dated 72 to 2000. It is reflected.
Yes, my lord. And that is the reason we have challenged this assailing the order, impugn order of the CM, my lord, because they have upheld the order of EM on 23rd December 2003, my lord. That is the main things.
If my senior friend is arguing the matter, then we can hear the matter, my lord. Or otherwise, if you want to submit the gist.
No, that is I am giving the gist, my lord.
My lord.
It may not be correct.
My lord. Here.
According to them.
They are trying to get a lineage from their father's side. But this is a maternal society. And it has to come from the mother's side.
Yes, mother's side.
What is legally correct that he will be placing before?
Yes, I will explain to that.
Now, since he has said that he will submit a gist, let him submit and we can argue the matter, my lord, in length.
Yes, my lord.
Because in the repetition, my lord, what happened? He has not enclosed all this document in the serial. That's why there is a lot of confusion. And then, in fact, he is the wife of the daughter of third wife. It is on record. He'll be coming to that. Now, he has relinquished the Nokmasip. He has relinquished. It is on record in my affidavit also. I saw it to lordship. It is there. Majumdar has inquired, and there was he has relinquished and relinquished means from the Nokmasip, and he married to some other lady. He was not substituted by the Mahari. Now the crack of the case is that he has relinquished the Nokmasip, and he already decided the family of the Nokma, and he with his own will that Jongshan married to some other wife, and he is the daughter of that third wife, which is not substituted by the Mahari, and is on record. It is Majumdar, and various order has been passed in this effect. In my
cutting short.
That is the case.
Cutting short the argument of my learned friend. The court has to decide only one factor. Is this, my lord? What is the right of the second wife and third wife? It is their lifetime right till they are alive. But if in case a daughter of the first wife who is the real Nokma, she claim I want to be the Nokma after she become mature or major, they have to give her. That is the customary law. That is the settled law. That cannot be changed. There is an order of this division bench also, where Justice T.N.K. Singh has passed an
my
order.
lord,
So this is the
Mahjong and
customary law. That cannot be changed, my lord. Now my learned friend has to show to this honorable court that
I will show.
that
Definitely, I will show. Definitely, I will show my claim.
Definitely, you show. Nobody will take your trust. Yes. Yes.
So what I am saying is this: my friend has to show that whether the third wife, kids, has any right over the Nokmaship.
Whether custom permits it or not.
Yes. The law is otherwise.
The prevailing custom.
Yes, the law is otherwise. The settled law.
And then the settled law means like this by virtue of some
Judgment.
precedents.
Yes.
And another here, my lord, Masung and the Mahari is the supreme.
There is no such book.
Yes.
There is book.
There is a book.
Yes. I have.
J. Sangma book. Justice Sangma has authored a book, small book, that has been relied by number of judges in different proceeding. And they say in that book it is very clear that the second wife or the third wife or fourth wife, they will have the right over the Nokmaship till their lifetime. Their kids has no right. This is settled law. I can show them.
That book is considered to be an authority.
Yes.
So far as the
Yes. Well, let him submit the gist. We can argue it next week itself.
What is the
Just summarize the case instead of going by the court, because if we say that
Because here the problem is this, my lord. They have challenged this order. Now order of the EM is there in the writ petition. Order of the CM is there. Order of the EM is not readable. They have again filed an additional affidavit to bring into type copy. Then, my lord, the applications which was filed before the EM and the appeal which was filed before the CEM, those are not there. Those should have been enclosed for a proper adjudication of the matter. Those things are very much pertinent. Because here, my lord, the issues which has been raised by my learned senior friend, whether this was the issues which are before the trial court or before the first appellate court, if those was not raised, my lord, subsequently he cannot raise a new
No, my lord, it will come in course of the argument, that is their contention. So at the time of argument, let them say anything what they are according to them, it is a fit case for them. Okay, my lord.
No, but then see the what is pointed out by the learned counsel is that if you do not include those documents,
I have
this will be
no, my lord. I have included by filing an additional affidavit.
That is what we have to go from one page to another page, my lord.
What happened?
And that was also by the order of this honorable court.
Yes.
We have insisted, my lord, and we have brought into notice of this honorable court.
So it means there are two additional affidavit by you. One bringing that judgment and order, type copy of judgment and order.
Yes.
Another bringing into records.
Additional document on record.
And supporting to my learned senior, there are a lot of things he has, like concealing the fact, like a lot of order has this. Because how we will understand, he has enclosed only two order. But there is a number of judgment. There should be a sequence from the beginning till the end. He has
Number of judgments in this matter involving this issue.
There are orders.
Since 1964.
There are orders, lower court, trial court, and all,
And the high court.
all those high courts. Those was not placed. The correct facts, what I can understand.
You have brought it into records. Have you filed an affidavit in this?
Time it's coming to the high court.
Have you filed an affidavit in this matter?
He has filed in the additional affidavit after argument only this one. It is
Yes.
It is
But
there.
it is on
We
record
have
now.
collected, but we have provided him to file it because
Now it is becoming a puzzle for this court.
No, sir.
How many affidavits are there? See, writ petition is filed apart from writ petition. There are two additional affidavits. One bringing into records the type copy of the judgment
Yes.
of the EM,
Yes.
and second is bringing into record
Order
the memo of appeal and
Yes.
No.
Other
That is
no,
some
other
document.
documents. Other documents he has
other
brought.
documents.
Other documents.
So these other documents include all the judgments which you say now.
Lordship,
All the series of judgments from 64.
Some we have enclosed that he has not enclosed it, but there is some judgment where we enclose in our affidavit in opposition.
It was even suggested by the court,
So
hearing the
he should
matter,
not file it.
to withdraw it and to file afresh with all the details.
No, that is already gone, my lord. We are in the stage of final hearing.
It was suggested in the stage of final hearing only, my lord, when the court became very puzzled about this matter.
No, even see, this court is finding it puzzling. That's why so many queries. You see, we have not gone into the That's the issue. Initially I tried to determine for the writ petition. Then I found that it started in a different way. You see, like you do not get the facts fast enough. That is precisely this court had pushed Mr.
No,
Hazarika
that is the
petition that
reason I will
the
file my
facts
case.
which is pleading. You see, otherwise this will be really difficult for this court.
Exactly, Lordship. Because it is not in sequence, Lordship. Because even this order affidavit in opposition which they have filed additional, here also it is not in a serial one.
No,
Serially.
all the documents are not.
Because he's jumping from one after another, from here and there. How court will decide? It's difficult for us also to follow. If he's just saying this,
He all along he was waiting for this court, you know. He has prepared the petition with a plan.
But other court have so recently said you find it all the document. Even then, court also find so difficult to understand because date is not in serial. Which order is which?
No,
my lord, I can suggest or make a prayer. Let him submit a gist or whatever he wants to submit, so that we can also be in a position to do justice to our client by placing our case properly. Because if we go with the writ petition, my lord, it will be very difficult for us also to place the facts.
District Council authority cannot say like that, my lord, because record are available with them.
My lord, it is not about the record. It's about we cannot contemplate what he is arguing. I have to prepare my argument on the basis of his claim.
Let him prepare.
Let him submit a gist.
I will submit to the court, my lord.
And let him also supply a copy to
At
us.
least if this court gets the facts.
Yes, my lord.
And the chronological list of orders and all which
Yes,
has in the past.
yes.
If that will help a lot
Yes,
for the
my
court
Yes, my
to come to
yes.
at least to get the facts, you know, like
Yes.
the
Yes, my lord.
otherwise it will be quite difficult.
Okay, my
If you can do it, this will be
Yes.
because things are, you see, some are here, some are it's just a scattered kind of things in one thing.
So
that is exactly what happened. Here and there.
He could have withdrawn and file a fresh.
He can file a fresh. Even if he
Liberty can be granted.
no, my lord, they are not a authorized person to direct me to withdraw it.
We are suggesting. We know who
They
we
cannot.
are.
They cannot.
Do not get offended by their submission.
No.
Their part remains as a submission.
Yes, my lord.
This
Yes,
court
my
has never told you to withdraw.
Yes, my
an
lord.
order.
But they are
This
telling
is
to
this
withdraw.
is an option.
That
It is always with you. It is to be
yes,
exercised
it
by
is
you.
my this
That is-
privilege,
that
my
is-
lord, whether I will withdraw or not.
That is
Yes.
see,
They cannot suggest me.
but then do not
They
get,
are my opponent.
Do not get
They cannot
offended by
suggest.
their
Yes.
submission.
They can make argument, I admit it. But they
that is
cannot
what-
suggest me to do this and that, my lord.
No, that is also a part of the argument. Making
Yes,
suggestions is
yes,
also part
yes,
of
my
the
lord.
process.
Yes.
If you admit that they can make an argument, then you should be ready for this kind of argument.
Anyway, my lord.
Now, then what do you decide? You will file this thing.
Guest, I will file my.
It's up to you. You see, like, this court
Yes.
will not force you to do anything.
No.
Only thing is that if you think that in this present situation also you should proceed,
as
court
the-
will definitely make
the
an
honorable
endeavor.
court also facing this trouble. So, in the guest also, I will chronological event all the document also I will enclose, my lord. So, I require 2 week
You
time.
give the factual, the story,
Yes, my lord.
basing on which you will be
Yes.
you'll be
Yes.
placing your case.
Yes, my lord.
That would be needed.
Yes, my lord.
The starting point and
Yes,
all.
yes, my
From who to who came and what
Yes,
is-
yes.
and the
In the-
lineage.
in the short-
your lineage.
Yes, my lord.
Okay, the things. Those things.
Okay.
But then do not make it very lengthy. You see, it
Yes.
should not be.
Yes. Okay.
Yeah, advanced copy may be supplied to us, so we'll be also in a better position to
Can be done.
argue.
Yes, it can be. It can be.
Both additional. Yes, not.
You have already filed your written argument. This is
Yes,
better.
ma'am.
It's an argument. But unfortunately,
It is there in your written argument. Is it from your written argument? Can we get the things, the facts and all?
Yes,
is it
ma'am.
chronological
Yes,
there?
yes.
If we get it, then
chronological is not required to file another affidavit. But
No, not affidavit, it is just
Yes.
synopsis.
This written
he has not supplied a written argument also.
your written argument seems much more better. It looks convenient than the other things.
Which is there, my lord. In short, I have written. Written argument.
I think your written argument contains the facts. I think. Have you seen that, Mr.
It was
Dave?
Where is it written?
Of course, the tax parts you will be knowing better.
You have received.
I have not received.
My friend has not received.
I will supply the copy to them.
Let them supply.
Written argument.
No, you see, whatever way you find it convenient, if you think that you should prepare a new list of this, up to you.
Yes.
See, but then what would help this court is that if you make a chronological list of facts and events,
Yes.
that will,
Okay.
that
is in the written argument also almost same. So I will.
it's all right. Then in such a case, we will not distinct. Then we can go and can proceed on the basis
I
of
will
it.
file, my lord. I will file. And here is I will file. This is the written argument and file. I will give the what document in which place are there in the petition or the addition. I will mention all these things in the.
So that we do not have to go here, there, and all.
Yes, my lord. Yes. So it will come
when can
easier.
you, when
for
can
the
you do
court
it?
also for me, also for other my friend also.
When can you do it?
After 2 weeks, my lord.
Shall we say in the order that you will find a this thing?
Yes.
Notes or like
The synopsis.
Yes, just like a synopsis I will make. From where I will start and where from I have get this one, I will mention all
You
this
do not
thing.
have a synopsis appended to your writ petition.
Yes, it is already there.
Like a writ petition also. Same writ petition also, synopsis also. Synopsis also filled for us. Yes, give me the synopsis. Is there?
There is synopsis appended to this. Like
Yes, it is there, my lord.
that will not suffice. That will not serve the purpose.
Not at
He
all.
has not mentioned many things.
No.
Not indicated.
Probably
I
he,
will file by the gist, my lord. I will file it after 2 weeks and with a copy to my friend.
Yes. Learned counsel for the petitioner, Mr. H. Hajarika, submits that he intends to file a more comprehensive synopsis in the matter before the matter is taken up for final hearing. The learned counsel for the respondents have also supported the petitioner in this regard. Accordingly, this matter stands adjourned for 2 weeks to enable Mr. Hajarika to do the needful.
A brief of the case.
To enable Mr. Hajarika to prepare and submit a comprehensive synopsis in the matter. The learned counsel should petitioner shall also supply the copy of the same
Yes.
to the learned counsel of the respondents before the matter is taken up for hearing. Yes.
Please submit what you want.
Hmm?
Yes, file this petition. Now, the document which he has not enclosed in the original petition, can he at the time of stage?
No, he will not bring a
compare it
fresh
with
documents
the
and all.
other-
Synopsis doesn't allow him to bring anything. These things, nothing.
No, whatever there, we have
File
submitted.
another fresh document.
See, whatever is there in your
No,
affidavit.
no, I will not bring any fresh document, my
there is
lord.
no
What I have submitted
No,
before
that
the court,
this
it will be confined to that only.
This you will have a right to raise objection if in case he brings something
Yeah.
which is not a part of record.
Lordship.
he should bring the papers in chronological way, my lord. It will be very easy for us.
That
also
is
to
why you see this comprehensive one. That's otherwise, if it is not chronological way, that will not help us. The situation will remain the same.
Same, yes.
Please take care of that.
Yes. Okay.
Just make it chronological order,
Yes,
so it
yes,
will be
yes,
better
ma'am.
for
Yes.
us, all of us. Even for you also,
Yes, ma'am.
it will become easier to please.
Yes, ma'am.
Disrupted please, no?
Item number 14.
Good Lordship. Here I am from the private respondent. My learned senior has filed that additional affidavit, Lordship. So I want to file short reply, Lordship.
This affidavit is just for the purpose of bring some documents.
Yes, Lordship.
Report.
So any reply is needed?
Yes, Lordship.
This will unnecessarily make this file bulky.
My lord, what my learned...
Then becomes difficult for the court also at the time of hearing.
Because, Lordship, I have only filed the counter. My friend has filed so many additional affidavit, then this is, I think, would be the third.
This is a practice which normally should be discouraged, you see, until
Yes,
unless there is a
Lordship.
compulsion. You have brought into the record spot inquiry report.
Yes, sir.
So what affidavit is needed against that?
That affidavit, my lord, that affidavit is not with regard to the status of the post, Lordship. Because when the order was passed in my favor,
No, but then that can be, even in your submission you can point it out.
And I just want to bring that when that sanction order also, when the school was brought under SSA, what is the sanction order, Lordship? And what was the condition in the sanction order? And I want to revert some points in the so-called inquiry report also. What is in what context the subordinate officer has conducted an inquiry to find out what, Lordship.
Mr. Day appearing for?
I'm also
Managing
for one of the
committee.
respondent managing committee. Yes.
Mr. Abraham is for the government.
I am now the
Government
fight
supposed to file
Inquiry by the government, conducted by
Yes.
the government.
So status of this teacher to be submitted by the state today.
Where is the affidavit filed?
I have.
Let's see. My God, how many affidavits are there already? 7, 8, 9 affidavits are there already in this matter.
In this case, Your Lordship, in my case,
Yes, 1 minute, 1 minute. This entire thing is your inquiry report. The whole.
this one.
It seems to be quite thick. You have brought in certain things which are. What the order said, the last order. You are only supposed to bring into the records only the report, nothing else. You are not supposed to bring anything else.
So only the inquiry report will be taken into consideration. And rest of the things I given.
This is very improper. You see, you should not have filed this affidavit. Should not have been taken into records. You have been permitted only to bring into records the inquiry report, nothing else. You have brought in so many documents.
Not only documents and statement has also been made.
This is something not very correct.
Even the registry should not have allowed this affidavit.
This is not in accordance with the order passed by this.
So then only the inquiry report may be taken into consideration.
You are ready for hearing this matter?
Actually, I beg only 2 weeks. I'll just respond to the inquiry report under what.
Even if you make this affidavit confined to the inquiry report, do you have this thing? You will have to file a reply.
Yes, Lordship. Lordship, my friend, my learned student, what he is saying that the inquiry with regard to the status, if my lord peruse the head note of the inquiry report. Here, when I file a pleader notice asking the department to comply the order which was passed in my favor, then director has issued a letter that this period to this period the money has been went to the account of the secretary. In response to that legal notice, Lordship, the managing committee has written a letter to the department that no, that period to that period, the money has never been credited into the account of the so on so on. That with regard to that part, they have clarified, Lordship. So I
It's
just
okay,
short reply, Lordship.
Pursuant to the
on clarification, your lordship was pleased to direct the state respondent to get a clarification who are the sanctioned teachers, and on top of that, how money has been transferred to the account of their respective teachers. For that, I got an instruction, your lordship.
Yes, okay, we will take it up on this at the time when you hear. Okay. This was order dated 24/8/2023. The petitioner has filed an additional affidavit on 19 September 2023. Stop. Though the petitioner was allowed to file an additional affidavit only for the purpose of bringing into records the inquiry report. Bringing to record one inquiry report conducted by the state authorities in connection with the payment of salaries of the teachers of the Singamari Girls SSA Upper Primary School, comma. The petitioner has brought in certain other documents along with the said inquiry report. By traveling beyond the order passed on the earlier occasion. On the order passed on 24/8/2023. 24/8/2023. The learned counsel or the respondents raise serious objection to that. Stop. Accordingly, it is ordered that only the relevant inquiry report shall be taken into consideration at the time of hearing of the matter. And the other documents and related averments made therein, in the said additional affidavit, would not be taken up for consideration. Stop. Mr. S.A. Sheikh, learned counsel, appearing for the respondent number
10, Lordship,
prays that a response is called for against the additional affidavit filed by the petitioner, and accordingly prays to allow him some time for doing the same, for filing the same, not doing that, for filing the same. Stop. Prayer allowed.
So it should be limited to only the inquiry, not
definitely. Okay. Before you write prayer aloud, stop. It is made clear that in the event of filing of any response by the respondent number 10, comma, the same shall also be confined to the shall also be confined to the inquiry report. Stop. List this matter after 2 weeks.
So you will receive this instruction from the government also may be taken to record.
That will increase in the day of the
Let's see what they say.
Can be placed at the time of hearing before, sir.
This matter after 2 weeks for enabling the respondent number 10. This is matter of 2 weeks. In the meanwhile, the respondent number. This is matter after 2 weeks. Give a full stop. Then you say in the meanwhile the respondent number 10 shall file his response. His or her. His response. Stop.
Mass obliged.
We have said already, no? List after 2 weeks we have said. Yes, call. Let us see what matter is there.
My lord, this matter was finally heard. And
Hearing was not concluded, my lord, because during the course of the
I had
inquiry.
closed my submission, and the state was directed to produce
That
the
teachers
Yes,
leave vacancy.
Yes, my lord.
Yes, leave.
Directed to produce the utilization certificate.
Yes. Then
My lord, we received the utilization certificate.
you have it in your thing.
We have it, my lord.
And then what about the allotment of fund after discontinuation of service of the petitioner?
My lord, the only two teachers are getting, my lord.
So therefore it's not.
No, my lord, that has been stopped.
And then you have the utilization certificate. What does it say?
My lord, utilization certificate, my lord, what they have produced from the managing committee, my lord, it shows the one of the teacher. The petitioner's name is showing, my lord.
It has been issued in the name of the petitioner all along.
Yes,
my lord.
And sanction also has been named in same name.
No, my lord. Sanction, I found out what is the system of sanction, my lord. Sanction normally goes to the school, my lord, as per the number of posts, sanction posts which a school is having, my lord. So there are some schools, say for example, my lord, where there are 4 sanction posts, some schools 3 sanction posts. There are some schools which are having 2 or 1 sanction post. So my lord, disbursement is only as per sanction. So my lord, when the authority is disbursing,
So it means the utilization, in their utilization they have showed the name of the
yes,
petitioner.
my lord.
But in spite of that you kept on this thing. You never stopped your sanction.
My lord, the sanction went on. That is a fact, my lord. Part of it.
Only in 2018 I think, is it?
My lord.
You said
My
that
from
you are
June
not
onward.
approving.
June onward. My lord, here.
This is one of the aspect. But then one thing is that, Mr. There will be difficulty for you, the legal difficulty all of it.
Yes.
Because the fact remains that you are working in a live vacancy.
My lord, I am in the fag end of my.
That is okay. But then see, like the problem is that the law, you see.
My lord.
The sympathy stands in one footing, the law in another footing.
My lord, as authorized also, my lord, my humble submission is that I will be covered by Umadevi's judgment.
Umadevi's judgment.
My lord, this
because I am qualified, I am within the age limit.
Will not apply in this case, my lord.
Umadevi's judgment, how it will be applicable here?
My lord,
you are in a admittedly in a live vacancy.
My lord, my lord.
And if you have at all any lien, you leave it in your previous appointment.
My lord, if I may, firstly, this is a sanctioned post. Secondly, I was within the age limit. I am qualified. And I am not seeking for regularization, my lord. I should be allowed to.
You were never appointed in that post, even in on ad hoc basis.
My lord, never appointed.
Managing committee has already.
Umadevi will not come into play.
Managing committee has appointed me also.
But my lord.
Now it is a communication between the managing committee and the authority concerned.
My lord, that's a clarification also if sought, my lord. There is no approval till date, my lord.
What happened to the post held by her in the before she came to this thing, lower primary section? That came to live vacancy. She was holding a post in the lower primary section.
Yes.
Prior to she was accommodated in the live vacancy. Yes. What happened to that post? There she was regularly selected.
Till now that post is still not advertised.
No.
So that school, that post is vacant for so many years.
No,
for more than 2
friend
decades.
did not get the
question
query
properly.
No, but then that will be relevant for the purpose of deciding this case.
My lord will kindly say one aspect.
About the present sanction post, not the one I left.
No. That the post which you left, what happened to that?
That is what the post I left in LP.
You should take instructions on that, my lord.
No, let him submit. This has been going.
In fact, they said
the petitioner may not have a legitimate claim so far as the post where she served as a live vacancy. But then one thing is that the post where she was appointed on a regular basis. What happens to that?
My only limited instruction is that post is still lying vacant because we have not appointed to anybody.
Even
now.
that lower primary section for more than 20 for 25 years the school is functioning without teacher.
Because
That is also a sanction post, isn't it? The lower primary.
No, my lord.
That is a manager's decision.
She was she entry into her service is through the managing committee, my lord. She was an appointee of the managing committee. Now, when the leave vacancy occurred,
No, but then this court now,
my lord,
desires to know about what happened to that vacancy. Of course, from managing committee, not from you.
my lord, in that matter, if I may submit, my lord, in between, my lord, when my lord, there was an order for the original incumbent where she had taken, my lord, she was supposed to resume her service. At that point, there was an order reverting her back, my lord. So at that point of time, managing committee, even if it is for a day,
order, but then those orders were never given effect to.
my lord, that is there. But if there is a question of
occasion, it seemed like that the original teacher came back, joined. These
My
are
lord.
all.
No, my lord.
See, basically, it was never given an effect to.
Only attention I am trying to draw to this honorable court, my lord, is that if that order of reversion is there, that means that post still remains. Now, as of date, I don't know what is the situation.
That is what we are interested to
That
know.
was in 2010.
now that what I got the instruction is that a post is not advertised. This
That even in the post which she was holding originally.
No, she was not originally holding. She was in.
Probably, Mr. Sangma, you are not very much aware of the fact. Prior to she came to discharge the duty of the assistant teacher, the post for which she is fighting now, she was appointed by managing committee in some other post. Now, what is the status of that post? That was prior to 1990s.
Yes, my lord.
I don't think you have any instruction on that.
Instruction, but
Do you remember the fact of the case?
Yes.
Are you sure?
But only that post, they said they actually once government has asked to advertise us with that post, but later on because of the case we did not advertise. That is the instruction. May that be case, that post is.
Let him obtain
My
the
lord,
instruction.
No.
See, in the letter also, when my friend has filed it there, that also is there. Committee as per the rule guideline, you are instructed to immediately advertise the vacant post in the local newspaper and conduct both written and exam personal interview.
You find out about the original post that she was holding. You take instructions. My lord, technically she should have been reverted back, my lord. Technically, my lord, she ought to have been reverted back, which perhaps the managing committee did not do. Instead, they instructed her not to come
What seems to
school.
be very unfair is that you allow somebody to continue their vote. You may say, but then you have no moral right to make this submission.
My lord,
It
of
is
course,
your
the
action.
mistake is committed. That, of course, is there, my
Mistake
lord.
is committed, you are playing with the career of one person.
Mistake is committed.
You
That
see,
is for sure,
perhaps, like you may not feel it personally, but then you are playing with the career of one person. That is what the problem is.
But my lord, that is admitted, my lord. Admitted that mistake is there. But my lord, at the same time, she has been compensated with the salary also, my lord.
She has been compensated, but then what will happen after retirement? Are you ready to give her all the service benefits?
My lord, she is.
My lord, I
only-
won't press for regularization, but my service should not be disturbed, and my arrears of salary should be given to me, and my absenting from the service was not due to my fault. I was prevented by the action of the government authorities.
Government
I was
authorities cannot be
willing to-
blamed, my lord.
No, this
Cannot be blamed.
post 2019.
Lordship, yes.
No,
So
that is
government
we are
authorities
not
cannot be blamed.
we are not on much onto those things.
My lord, one of the
But then the
priorities
thing is that
My prayer is, my lord, to
So far as your claim for regularization in that post, that is where the problem is. Uma Devi operates in different arena.
in that case, I pray, your lordship, let this matter come after a week. I'll satisfy your lordship.
And that is what we have to hear on points of law.
Some hearing is required, my lord. Some
I
hearing
agree.
is required. In the meantime, my friend.
Your utilization certificate will remain with you.
My lord,
Yes.
it is here, my lord.
Just see. Heard Mr. Adgurung, Learned Counsel for the petitioner. Also Mr. K.P. Bhattacharjee, Learned Government Advocate for the State Respondent number 1 to 4, and Mr. P.T. Sangma for respondent number 5. It has been submitted by the Learned Government Advocate that as per the order of this court, necessary instruction has been obtained. And the same can be placed before the court at the stage of hearing of the matter. Mr. R. Gurum, Learned Counsel for the petitioner, prays that the matter will be taken up after a week, so that he can please relevant laws. He can place decisions which would be relevant for the purpose of. He can place decisions which would be relevant for the purpose of deciding the matter. Stop. This matter after
2 weeks.
2 weeks. Then Mr. What you said, Mr. Argung, just we say, please, last part. Okay, after 2 weeks, is it? Yes. Decisions on the point of law. Just write decisions on the point of law. Okay, which will be relevant for the purpose of. Then this the matter after 2 weeks.
Deeply obliged.
There is no other matter.